seated.
Good evening and welcome to the finals of the 29th Wabash College Moot Court competition. This event is co-sponsored by the Rhetoric Department and the Indianapolis Association of Wabash Men. My name is Jeff Drury. I'm an associate professor in the Rhetoric Department, and I'm also the campus organizer for this year's competition. The competition began back in September when students received access to this year's challenging legal problem. The students read the document thoroughly. They learned the facts and the legal basis behind the problem. They prepared a cogent case, and then they developed oral arguments for delivery. This past Saturday morning, the students argued the case under intense questioning by alumni, faculty, and staff judges. They did all of this as an extracurricular activity, and they began at 8:30 a.m. on a Saturday, so they deserve some credit for that, if for nothing else. Of the 35 participants in the preliminary round, 13 advanced to the semifinals, and this evening we're joined by the 4 finalists that you see here on stage behind me. Before introducing the advocates, I would like to give some acknowledgments for the people who make this event possible. First, I want to thank the students, alumni, faculty, and staff who judged and competed in the tournament. Without them, obviously, the competition would not happen. I also want to acknowledge Professor Scott Himzel, who helps me organize on campus and works with the pre-law students to drum up support and participation in the event. John Pachter, who is our alumnus rep to the Indianapolis Association of Wabash Men. He created the program that you have in your hands right now, and he also works to arrange the alumni judges that come back to campus. Matt Griffith, who is our bailiff this evening, works with the tutors to help prepare the students for arguing the case, and he also helps with a bunch of logistical elements, and he judges the semifinals. Jane Ann Himzel was our case writer for the 4th year in a row, and so we're grateful for her support with that as well. And Luis Rivera, class of 2023, who was my student assistant this past Saturday. All of them were very helpful in making this event happen. Beyond them, I also want to acknowledge Julia Phipps, Amber King, the Alumni and Parent Relations Office, Bon Appetit, Brandon Rash, and Campus Services. A full list of acknowledgments is in the program that you have before you, but would you please join me in recognizing these people? So our program this evening is as follows. I will introduce the finalists in a moment based on their speaking order. Professor Scott Himzel will then introduce our panel of judges. Each advocate will then have 12 minutes to present his case, first the petitioners and then the respondents. And these arguments will be interrupted by judge questions as the judges see fit to ask them. The judges will then retire to their chamber to confer before they announce this year's top advocate. After that, we'll take some photos, and then you're welcome to receive our advocates in Littell Lobby for a brief reception following the event. So let me introduce our participants tonight. For the petitioners, we have Jakob, Goodwin, and Liam Buckley. They represent 3 American Samoans, Tilo, Gabbard, and Gabbard, in this appeal. Jakob Goodwin is a senior from Indianapolis, Indiana. He's a political science major and a religion minor. He resides in Martindale and is involved on campus with the Pre-Law Society, the Bachelor, and the Center for Innovation, Business, and Entrepreneurship. Following Wabash, Jakob plans to attend law school in the Midwest. Jakob noted that he enjoyed this year's competition specifically for offering a challenging problem, but one that's not as politically controversial, in his words, as some of the prior year's topics, and so he enjoyed that element. Liam Buckley is a senior from New York, New York. He's a political science major and a Spanish minor who resides in Rogie Hall. On campus, he's involved with the Pre-Law Society, College Democrats, the Glee Club, and Fiji. He plans to work in politics before attending law school, and he has the goal of becoming a public defender. He commented that moot court at Wabash is what solidified his interest in the law, and that the annual competition has been a meaningful part of his entire Wabash experience. Would you please join me in congratulating Jakob and Liam? Jackson Grabill and Seth Kirkpatrick represent the Respondents, or the United States and the government of American Samoa. Jackson Grabill is a junior from East Lansing, Michigan. He is a PPE major and a rhetoric minor. He's a member of the soccer team, Sigma Chi, the Sphinx Club, Wabash Democracy and Public Discourse, and is a writing consultant in the Writing Center. Jackson plans to pursue law school post-Wabash. We might be seeing a trend at this point. He appreciates how Moot Court has taught him to think on his feet and to develop persuasive arguments, skills that he hopes to use in that eventual career. Seth Kirkpatrick is a junior from South Bend, Indiana. He's a double major in political science and rhetoric with a minor in Spanish. He's a resident of Martindale Hall and is active with Pre-Law Society, La Alianza, WDPD, and student government. After Wabash, he wants to go to law school and then return to his hometown to help with its economic and civic development. Seth said that he found the process of honing his Moot Court skills this year both exciting and intellectually engaging. Congratulations to Jackson and Seth. And at this point, I will pass the microphone to Professor Scott Himsel, class of '85, who will introduce our judges.
Well, good evening. Serving as our Chief Justice this evening is the Honorable James P. Hanlon. Judge Hanlon received his undergraduate degree at DePaul University, maybe you've heard of it, and his law degree at Valparaiso University. He's enjoyed a great reputation both as a federal prosecutor and as a criminal defense attorney, specializing in white-collar criminal defense. He's a published author and frequent speaker in the area of federal criminal practice. In 2018, the U.S. Senate unanimously confirmed his nomination to the United States District Court for the Southern District of Indiana in Indianapolis. Judge Hanlon, it's great to have you here. Welcome to Wabash.
Thank you. It's great to be here.
Judge Margaret Robb is a graduate of Purdue University and the IU McKinney School of Law. Prior to taking the bench, she had a wide-ranging general practice of law for 20 years in Lafayette. In her 24 years subsequent on the Indiana Court of Appeals, she has had a tremendous impact on Indiana law and the administration of justice in our state, with too many awards to mention. She's a frequent visitor on our Moot Court panel, and also here in Montgomery County as part of the Court of Appeals' wonderful program of taking their arguments on the road to the people of our state. It's great to have you back, Judge.
Thank you.
Our alumnus judge is Mr. Vince Bizarre. Mr. Bizarre graduated from Wabash in 1964, a member of Lambda Chi Alpha. He then received his law degree from the University of Michigan. He's had a distinguished career as an appellate lawyer in New York State and has chaired the Council of Appellate Lawyers of the American Bar Association. He's lectured across the nation on appellate practice. He's contributed extensively to the administration of justice in New York, including as president of the New York State Bar Association. Mr. Bizarre, we're thrilled to welcome you back home to Wabash. And finally, our faculty judge this evening is Dr. Sabrina Thomas. She earned her bachelor's degree at Colorado State, her master's at Butler, and her PhD at Arizona State. She holds the David A. Moore Chair in American History and chairs our history department. She enjoys a wonderful reputation as an excellent teacher and writer. Her current work includes a course this semester which addresses the themes of class, race, gender, and citizenship in the U.S. territory of Puerto Rico. Dr. Thomas, thanks very much for joining our panel tonight.
Okay, we are ready for the first argument, please. Mr. Goodwin.
Mr. Chief Justice, and may it please the court, my name is Jakob Goodwin, and I represent the petitioners in this argument. In very few cases, this court decides, is the plain text of the Constitution enough to answer the question at hand, but this is one of those few. Section 1 of the 14th Amendment says all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. The only issue left to determine if American Samoa is part of the United States, and neither side here contends that it is not. This case is that simple. But even if it isn't, the common public meaning of the 14th Amendment, and particularly the Citizenship Clause when it was passed in the late 1860s, was clear in what they understood. Contemporary judicial opinions and judicial opinions from before the Citizenship Clause make that obvious. Loughborough v. Blake, where Chief Justice Marshall said that territories west of the Missouri were not less part of the United States than Maryland or Pennsylvania. In Paquette v. Swan, Justice Story said that citizens of territories are citizens of the United States. In Cross v. Harrison, this court ruled that the California Territory was part of the United States. And in Crandall v. Nevada, it ruled that the most remote territories were part of the United States. Respondents argue that...
May I interrupt just a moment, please, counsel? If it has a plain meaning, how's come you have to resort to maps, dictionaries, comments, and other matters which really can't be applied unless it's by nature ambiguous?
Well, Your Honor, I don't believe you have to, but I believe that if this court were to find that the plain meaning of the text of the 14th Amendment were ambiguous, we could look to the plain line of history that this court has always looked at and what those words meant when they were written. It's not necessary that you overcomplicate this case when the text of the 14th Amendment.
So even though territory is not in there, you say the plain meaning it applies without the word being in there?
Yes, Your Honor, because as they would have understood, it's baked into what they meant by in the United States.
Okay, Counselor, I'd like to back up. You began by making a statement that the plain language is so clear. If the plain language of this provision of the Constitution is so clear, why were residents of every other territory given citizenship through acts of Congress?
Well, Your Honor, that was only the case because this court in Downs v. Bidwell had previously erred and created this distinction between incorporated and unincorporated territories when the drafters of the Citizenship Clause never would have understood or recognized a difference between the two. In 1900, when the land was ceded to the United States by chieftains in the American Samoa, the common understanding before Downs v. Bidwell in 1901 would have been that of course they were part of the United States, and of course the 14th Amendment would extend that far. It was only in Downs v. Bidwell when this court erred and relied on some kind of frankly racist reasoning to not extend citizenship to certain unincorporated territories, creating any kind of issue here at all.
Mr. Goodwin, can you think of any other situation where the extension or the application of a constitutional right depends on a statute? I mean, don't we judge constitutions independent of, I mean, aren't the statutes, in a sense, contingent on the Constitution, not the other way around?
Yes, Your Honor. The Constitution is the kind of standard bearer that any legislation must be held to. However, the fact that this court had not previously held any legislation to be unconstitutional because it had never taken the question up.
So is this, in a sense, kind of an anomaly that has not been repeated in other constitutional interpretation cases?
I'm not sure about other constitutional issues, but particularly on this one, it's right to note that Congress has been the arbiter of decisions like this in every other case, but that isn't necessarily correct. The fact that this court had let Congress go so far to kind of correct the record does not mean that this court in this case cannot take up its role under Article 3 to decide this question.
So if the answer lies in the plain text of the Constitution, were the acts of Congress giving citizenship to residents of other territories, is that entirely redundant, unnecessary?
Yes, Your Honor. They would have been wholly redundant and unnecessary because the understanding of the 14th Amendment should make clear that the people of the American Samoa and of every other territory of the United States would fit.
But don't all those cases indicate a common understanding that congressional action is required? I mean, doesn't the cases cumulatively demonstrate that that's the way it's been interpreted?
Well, no, Your Honor. If we look to all of the cases that I had previously mentioned, these were all before the 14th Amendment, and the drafters of the 14th Amendment would have all had them in mind. And particularly looking at what they had in mind when they wrote it, Senator Howard, who drafted the Citizenship Clause, borrows from Senator Trumbull, who upheld the 13th Amendment, who understood that in the United States meant everywhere, the states, territories, and Washington, D.C.
How do we know what a drafter meant? What do you mean by that? Aren't we bound to only rely on the text of the amendment?
Well, yes, Your Honor, but I think this court has looked at particularly in D.C. v. Heller, and said that we should look to the common understanding of what the language meant, meaning we can look particularly to what the drafters meant when they wrote the amendment. And if we look to news articles and testimony that they gave in Congress while they were debating the amendment, we can look and see that the drafters of the 14th Amendment Citizenship Clause, there was no ambiguity as to whether or not the territories of the United States would have fit that. And we can look particularly to Alaska, which they had just had experience bringing into the Union, that it was previously understood as unincorporated in the sense that when taken, it was not meant to be a state. However, that did not change whether or not this court found that citizenship extended all the way out to people in Alaska, and it wouldn't have changed any of the other territories that were not yet states in the 1860s. I'd like to, you brought up the maps and dictionaries, and I would just like to particularly mention that the United States has a kind of consistent record of considering these places territories and as part of the United States. And we can look to census data from the 1800s that includes Alaska and California and all sorts of other places that were not yet considered states.
Let me ask about Alaska. As I read the majority, or as I read the opinions, and you now cite Alaska as an example of a common understanding of the language.
Yes.
So how do you explain the fact that Congress specifically granted citizenship to the citizens of Alaska when under the treaty under which it came to the United States?
Well, Your Honor, I think I would point you to the question that Justice Hanlon asked me and say that Congress was simply over-redundant in ensuring that Alaska was specifically included in citizenship and then in statehood. And we see this kind of track record in multiple occasions. We see this in the 13th and the 14th Amendment, that the 13th Amendment's understanding would have extended.
But isn't the fact that the Congress enacted a treaty during this period of 1866 and 1868, specifically granting citizenship to the citizens of Alaska, unincorporated association, doesn't that indicate a common understanding of what the words mean? It meant Congress needed to act.
I don't believe it does, sir. I believe that their action doesn't necessarily force you to read into what they wrote to say that, and especially because it was brand new territory, I think we can read that because it was brand new territory, they wanted to be certain that they were redundant with that. We're now roughly 30 years past the drafting of the Citizenship Clause. When we come to the issue of the American Samoa, we can look to the example of Alaska, where they were redundant to ensure we knew exactly what they meant as we apply this to the American Samoa. I'd like to turn to the issue of the common law and how, as another way to look at how they would have exactly understood what in the United States meant and why that would have meant the American Samoa. In Dred Scott, this court erred, and then in with the 14th Amendment, Congress and the people, in ratifying the 14th Amendment, took the power away from Congress and from the courts took this power away from Congress to decide citizenship or person in the United States meant. They specifically took it away, returning us to a common law precedent, understanding that if you were born in the United States, whatever that meant, and in this case, meaning in the American Samoa, you were obviously guaranteed citizenship.
Let me ask you a question, Mr. Goodwin. You talked about the Dred Scott decision. Many have said that the basis for this decision really has its roots in racism. What does the Dred Scott and its progeny tell us about the result of this opinion?
Well, Your Honor, I think when we look at Dred Scott and then we connect that to the insular cases, which both come from kind of frankly racist reasoning in which they meant to take away autonomy from other people, that we can take that and the fact that this court has wished not to extend Downs v. Bidwell, the case the petitioner or the respondent relies on, that when they mean to say that they don't want that extended, that this court has found that it doesn't want to extend that kind of racist rhetoric and racist reasoning that come from it. I think this court ought to look at that. May I complete real quick?
Can you finish the statement?
Your Honor, the court should look at that kind of set of reasoning and the fact that this court has wished to change course from the insular cases and from kind of the racist reasoning of Dred Scott and decide to overturn the lower court. Thank you.
Thank you, Counselor. Mr. Buckley?
May it please the court. My name is Liam Buckley, and I represent the petitioners in this case. The Court of Appeals failed to protect petitioners' rights under the Citizenship Clause of the 14th Amendment. We ask that you reverse their decision. The Constitution empowers the judiciary to protect the rights established by the Constitution, and this court need only look at two texts in order to come to that conclusion. First, Article 3, Section 2 of the Constitution, and I quote, "The judicial powers shall extend to all cases in law and equity arising under this Constitution." And secondly, the Citizenship Clause. "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. American Samoans are residents of the United States. Therefore, the 14th Amendment's guarantee of birthright United States citizenship applies to them."
Mr. Buckley, let me ask a question about the constitutional interpretation. It would appear that the decision often in this case rests on the popularity of the ultimate decision. Why do you believe that's not the way in which we make constitutional determinations?
I absolutely agree, Justice Robb. And the reason is because the Constitution exists to protect certain rights that we've decided, that the framers have decided, should not belong in the political cauldron, should not be influenced by that sphere. And it's important that the judiciary branch effectively enforce the rights bestowed upon Americans in the Constitution. And American Samoans are residents of the United States. This court, not Congress, is the only authority when it comes to enforcing that right.
But how do we know that all residents of Samoa want citizenship in the United States? Is this something that should be foisted upon them by a court that is unelected and unaccountable, or why should it not be left in the hands of the Congress?
It's true, Your Honor, that some American Samoans do not wish to become citizens, but consent of the governed is not a necessary standard to fulfill when we apply constitutional rights. If that were the case, states like New York could tomorrow, by popular referendum, pass a law banning the private ownership of firearms. It means that by popular referendum, states could brand free speech or press outlets. It's important that we protect the rights in the Constitution, regardless of whether or not the people necessarily consent to them. And if they wish to change it, they're welcome to pursue the branches by which to do that through amending the Constitution, as they did with the 21st Amendment.
Is it your position that, laying aside the congressional arguments that under common law and the other cases that are cited in the opinion, that they would be entitled to, they would be required to be citizens of the United States, laying aside the Constitution just based upon the law?
It is, Your Honor.
Well, if that's the case, doesn't that permit this court then, if it's not a constitution, assuming it's not a constitutional right, then this court, Supreme Court of the United States, can fashion whatever remedy we think appropriate? Would that also be right?
I would disagree with that, Your Honor.
Good. What about, it's not just a few of them, I mean, the interveners in this case don't want to become citizens of the United States. They have tribal rights and everything, all the other culture that they have. Shouldn't we take that into account in some respect about these people being forced to do that? And isn't the Congress, in balancing those interests, the better place to do it rather than the courts? We have no real way of telling whether culture outweighs some other consideration.
That's true, Your Honor. I would point to 2 points. Firstly, the Elk case, in which this court held that a Native American born in the United States was in fact a citizen, but that he could renounce that citizenship or his allegiances to his tribe. That is the same case as the Samoans. Should they wish to renounce their U.S. citizenship, they're welcome to do so at any point in time.
But it wouldn't the easier solution be which is the existing situation where Samoans can remain citizens, not citizens of the United States, and those who aren't, don't want it to be that way, want to be a U.S. citizen, they can be fast-tracked to being a U.S. citizen easily. Now, isn't that a more equitable remedy rather than disrupting all of the history and culture of these people?
Your Honor, the Constitution says you get to be a citizen because you're born here.
But we laid aside the constitutional argument. Now we're out where the Constitution doesn't. We're in the area where we're going with the common law, and we can fashion a remedy that we deem appropriate.
I would disagree with that contention, Your Honor. I believe the only remedy lies in a plain text reading of the Citizenship Clause of the 14th Amendment.
Mr. Buckley, what are the benefits of citizenship for American Samoans?
There are a number, Your Honor. First and foremost is voting rights. The respondents have contended in this case that American Samoas could pursue citizenship through democratic means. Next month, American Samoans will head into the ballot box and elect a member of Congress who will not get a vote. That is a harm that has been done to the American Samoan people, and they deserve to have that remedied by the Constitution. And it was in that frame that the Reconstruction Congress passed the 14th Amendment. And the precedent of this court in Wong Kim Ark reaffirms the meaning of the Citizenship Clause, and I think demonstrates the role that this court should take. In that case, the court held that a man who was born in the United States to Chinese parents who were not citizens was in fact a citizen, and they said that the 14th Amendment affirms the ancient and fundamental rule of citizenship by birth, and that the Citizenship Clause, in clear words and in manifest intent, includes children born within the territory of the United States.
And what would the consequences for the federal government be to make American Samoans American citizens?
Well, they would be then entitled to a similar set of rights as is conferred upon every United States territory that is not American Samoa.
And why are those consequences?
They would be allowed to participate in political primaries, for example. They would be allowed to freely travel, work, and know that their constitutional rights are protected in any state in the Union.
And why are those consequences?
Because without that protection, American Samoans are not full Americans.
Mr. Buckley, would it be fair to suggest that becoming a naturalized citizen does not afford all of the same rights as someone with birthright citizenship? In other words, are there rights that a person with birthright citizenship have that naturalized citizens do not?
There are not, Your Honor.
Run for president of the United States?
Oh, yes, you're right, Your Honor. Run for president of the United States, vice president. I think an important thing also is to recognize the children of citizens. The right to establish a family and know that your offspring are protected by the same Constitution under which you've pledged your allegiance to is fundamental establishment of our country, and it's why in the Wong Kim Ark decision this court referenced the 14th Amendment as affirming what was already agreed to be a constitutional right, the right of birthright citizenship, the right that was conferred by common law for hundreds of years.
And what about the consequences, again, this time for American Samoans and their culture? Somebody brought this up a little bit earlier. So how do you contend with the history of the United States intervention in other places damaging the culture of those places?
That's an important concern, Your Honor, but with due respect, I don't believe the Constitution is concerned with that. The Constitution is plainly to be applied to territories and people living within the United States, and whether or not that may have a negative impact on the cultural structures of American Samoa is not the issue of this court. The issue of this court is to apply the 14th Amendment to American Samoans.
Mr. Buckley, you mentioned the Wong Ark case earlier. That case did not involve this issue of territories. We do have precedent that the phrase United States does not include unincorporated territories. So are you suggesting that we directly overrule Downs and its progeny?
My time's expired. May I answer your question?
Yes, please.
Your Honor, I don't believe that doing so would be an overturn of Downs, because I think the scope of Downs was very narrow. It referred to the Tax Uniformity Clause. What's important about the Citizenship Clause of the 14th Amendment is that it defines its own geographical scope, and that scope is the totality of the territories and states of the United States. And with that, Your Honors, we humbly ask that you reverse the decision of the Court of Appeals. Thank you.
Okay, thank you. Okay. Mr. Grabill?
May it please the court. My name is Jackson Grabill, and I represent the Respondents, the United States of America, and the government of American Samoa. The Court of Appeals was correct in finding that the petitioners are not United States citizens under the Citizenship Clause of the 14th Amendment for 3 reasons. First, the plain text of the Citizenship Clause is indecisive. Second, the history of the Citizenship Clause is ambiguous and sometimes conflicting. And third, longstanding U.S. government practice does not recognize the natives of American Samoa as United States citizens. In this case, the plain text of the Citizenship Clause is indecisive. The geographic scope is unclear. The Citizenship Clause reads that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. The 13th Amendment, on the other hand, applies to all areas, quote, within the United States or any place subject to their jurisdiction.
Are they not subject to the jurisdiction?
Your Honor, American Samoa is subject to the jurisdiction of the United States.
Would it be fair to say that the Constitution's purpose is to protect the minority, where statutes are designed to represent the majority view?
That would be fair, Your Honor.
Why then, in interpreting the document that protects the minority, are we bound to follow the majority rule?
Your Honor, we're not bound to follow the majority rule.
Isn't that what you're arguing?
No, Your Honor, I'm not arguing that. I'm arguing that we must look to the plain text to see if it resolves this case. And in this case, the plain text does not resolve the case. We do not, the meaning of in the United States is indecisive. If the framers of the 14th Amendment intended for the 14th Amendment Citizenship Clause to apply to all areas under United States jurisdiction, then they would have written that explicitly. They could only have looked to the 13th Amendment, ratified just a couple years before the 14th Amendment. Instead, they wrote the Citizenship Clause to apply to all persons born or naturalized in the United States and subject to the jurisdiction thereof. The 13th and 14th Amendments clearly have different geographic scopes, with the 13th Amendment's scope being more broad than the 14th Amendment.
Is it your position that people who were born in the incorporated territories, are they automatically covered under the Citizenship Clause?
Your Honor,
regardless of where they are, regardless of scope, aren't they citizens?
Your Honor, people in the incorporated territories are citizens.
Tell me again.
I said, Your Honor, people in the incorporated territories are citizens via congressional act, not via extension of the Constitution.
Wait a minute. Incorporated, you're saying that citizens in incorporated territories only become citizens by acts of Congress?
Your Honor, they're citizens under the birthright citizenship in the Citizenship Clause, but the extension to those territories came via congressional act.
So if you're a member of if you're in a territory, an incorporated territory, you become a citizen. Is that your position? But if you're in an unincorporated, you don't. It takes a congressional act, or are you saying it takes a congressional act for both?
Your Honor, my position is that people in the unincorporated territories, like American Samoa, are not United States citizens based on birthright citizenship, but people in incorporated territories are.
Automatically?
Well,
regardless of where the territory is, under the Constitution?
Regardless of where the territory is, yes.
Right. So this distinction between incorporated and unincorporated, that came up in the early part of the 20th century, right? It didn't have anything to do with the framing of the Citizenship Clause or the amendments.
Yes, Your Honor, that is correct, but that just shows that the framers of the Citizenship Clause had a different idea of the territories when they were drafting and ratifying the clause. They were influenced by ideas of manifest destiny that had an overly expansive idea of what is included in the United States. The drafters and ratifiers of the Citizenship Clause were not addressing or thinking about the issue that we are dealing with today. They were thinking about territories that they believed were all destined for statehood. Today, we are dealing with the issue of citizenship in an unincorporated territory never destined for statehood.
So the framers didn't have an opinion one way or the other on whether or not it had to be incorporated or unincorporated, because the concept hadn't been discovered yet, right?
Yes, Your Honor, but we can assume that the framers had an idea of of territories different to the idea of territories we had today. they had a different understanding of the concept of territories and how they're related to the United States. Today, we have a very different understanding of territories and their relationship to the United States. Additionally, the history surrounding the Citizenship Clause is ambiguous and conflicting. Garcia versus United States established that isolated statements are not impressive legislative history. The Court of Appeals dissent only cites one statement from the legislative history around the time of ratification. This is not persuasive legislative history in determining the original meaning of the clause. Additionally, not all of the maps and dictionaries had the same understanding of in the United States to include the territories. An 1830s map is a map, quote, a map of the United States and part of Louisiana. Louisiana was a territory and not included within the United States. Additionally, an 1867 dictionary does not include the territory of Alaska in the United States.
I want to ask you, shifting gears real quick here, about the precedent of this court. As you know, the court takes the concept of stare decisis very seriously, that we follow the precedent of the court. It's important for law to be stable. We're faced here with the choice between the insular cases and then long arc. On the other hand, how does the precedent of the court, as opposed to history, legislative history and all this, how does the precedent of this court bear on this issue?
Your Honor, the precedent of this court when dealing with issues related to the application of the Constitution in unincorporated territories was established in Downs, not Wong Kim Ark. Wong Kim Ark did not deal with the issue of the unincorporated territories at all. The insular cases specifically established the framework for applying the Constitution in unincorporated territories like the American Samoa.
Let me interrupt you for a second. Would it not be fair to say that the insular cases are based on racist categorization of people, and what does that say about us today, even if you believe in an originalist theory of interpretation?
Yes, Your Honor. It would be fair to say that the insular cases were influenced by racist and imperialist ideas, but this case presents the court with a unique opportunity to repurpose those cases to protect the culture and autonomy of the American Samoa.
But does culture really determine whether something's constitutional or not?
No, Your Honor.
Or should
it doesn't, but the culture and traditional way of life for American Samoa has to be at the center of the court's considerations in this case. Today, the petitioners asked the court to impose citizenship on all American Samoans against their will. This would destroy their culture and traditional way of life. So in deciding how to resolve this case, yes, culture should be within the court's consideration.
Could I ask you a question following up on the other judge's question? There's great emphasis placed on Downs, which was sort of the father or mother of the insular cases, and you rely on that, right? Should this court rely, following up on Judge Robb's case or question, that was dicta in a plurality opinion based upon a racist theory, right?
Your Honor.
Should we rely on such an opinion?
Yes, Your Honor.
Should it have any value?
We must rely on this opinion in this case. Justice Kennedy summarized the meaning of the insular cases, writing that the court devised in the insular cases a doctrine that allowed it to use its power sparingly and where it would be most needed. The court has repeatedly applied the insular cases framework in the past century when dealing with how to apply the Constitution in the unincorporated territories.
On citizenship cases?
Not that I know of, Your Honor. But following the insular cases framework allows us to tailor a decision that both fits within the constitutional structure while protecting the culture and autonomy of American Samoa. I would like to return to the text briefly, Your Honor. Another important consideration when dealing with the plain text of the 14th Amendment is the very last part of the citizenship clause and of a state wherein they reside. This final clause is crucial and suggests that the framers foresaw all territories eventually becoming states. This just again shows that the framers had a very different understanding of territories, and in the citizenship clause, we're addressing a different issue than the issue we deal with today. They were responding to the issues of their time immediately following the Civil War. They were not thinking about territories like American Samoa and how citizenship might apply in those territories. Again, the history is also indecisive. There's conflicting evidence showing that there was no common understanding of the meaning and geographic scope of the 14th Amendment at the time of ratification, and extending citizenship to the people of American Samoa via this court would constitute a serious violation of historic government practice and would be unprecedented. The plain text, I see that I'm out of time. I have a moment to conclude. The plain text and history surrounding the citizenship clause are ambiguous. We must leave this issue to Congress, as they are equipped to handle this issue with a legislative scalpel as opposed to a judicial bludgeon. For these reasons, we respectfully request that this court affirm the Court of Appeals decision.
Okay, thank you. Mr. Kirkpatrick.
May I proceed?
Yes, please.
Chief Justice and Your Honors, may it please the Court. My name is Seth Kirkpatrick, and I represent the United States of America and the government of the American Samoa. We submit that Congress should play a preeminent role in declaring the citizenship of the peoples of the American Samoa for two reasons. First, Congress's power to do so for residents of unincorporated territories is backed by the Constitution, this nation's history, and this court's precedent. And number two, Congress is in a far better position to handle the cultural sensitivities of the people of American Samoa and their way of life.
Mr. Kirkpatrick, let me ask you the same question I asked your colleagues. Why should cultural determinations guide what we believe the Constitution provides?
Your Honor, I believe that the cultural sensitivities is a reason to allow Congress to handle this issue because they are in a better place to assess how to apply citizenship, but also because there's a distinction in the Constitution that is of great significance to this case today.
But why should Congress tell us what's constitutional if we're interpreting the Constitution?
Your Honor, in this scenario, Congress is not telling us what is constitutional because the Constitution does make a distinction between territories and states. Article 4, the 14th Amendment, the Citizenship Clause, talks about in the United States and in the state wherein they reside. But if we go back to Article 4, the Constitution explicitly mentions territories and other properties of the United States, which Congress has the power to delegate and have control over, which was then backed up by Sims v. Sims, 1899, stating that Congress has entire dominion and sovereignty over these territories. This distinction matters because it demonstrates that by not declaring the citizenship of the people of the American Samoa, Congress is not violating the Constitution and is working within inside it.
Mr. Kirkpatrick, how is Congress qualified to determine the cultural sensitivities of a people when there is no representative of those people in Congress?
Yes, Your Honor, I understand that concern, though I would turn the Court's attention to the power of Congress in policymaking. When handling the cultural sensitivities, they have far more resources to understand the people, speak to their government, as they did in 1900, 01, and 04. They have more subcommittees, resources, and abilities to be able to gauge how to apply citizenship and what decisions need to be made between themselves and the American Samoan government.
As they did in 1901 when they decided that the people of Samoa and other unincorporated territories were not fit for citizenship.
Yes, Your Honor, though I would like to mention that that was a deal between the American Samoans and the United States. There was no indication on either side that either wanted citizenship, and it was a consensual and voluntary decision to be part of the United States, though not including citizenship.
Is it your position that all the maps and dictionaries and other contemporaneous documents demonstrating what was considered to be a territory at the time. Is it your position that those are irrelevant because they don't distinguish between unincorporated and incorporated territories?
No, Your Honor. While not determinate, I do believe that these pieces of evidence, such as the maps and the definitions, are significant because they do play into the actions of Congress prior to the 14th Amendment. That being, whenever there was a territory, Congress, as per Article 3, would have a treaty between themselves and that territory. And through that treaty, Louisiana, Florida, and Alaska would gain citizenship. It was a consensual process that took steps, and I believe that the unincorporated territory, that distinction, is a development out of that. The development of acknowledging, as Justice White would say, or Justice Harlan would say in Reed v. Covert, 1957, that you have to understand the particular time, the particular purpose, and the particular place of a territory and its relation to the United States. In this case, with the American Samoa, we understand that their position is that 100 years ago, we struck a deal that we would not make them citizens as to respect their property rights and their way of life, and we have upheld that. And because of their position to us, and because of that role that we have made them 100 years ago, their position is that they do not want to be citizenships, but they do have multiple advantages on an individual level to become citizens.
Can you define consensual?
Your Honor, from the basis of my knowledge and the basis of what we have before us, I would define consensual as two parties agreeing to the same terms.
I want to ask you, Counselor, about the precedent of this court, which I think is an issue that we have to confront head on. As we've already talked about a little bit, there are some problems with the insular cases. They perhaps are cases that need to be overturned, as the court is inclined to do with cases that were flatly wrongly decided. Here we have a case, Wong Kim Ark, that is very explicit, saying that the citizenship clause must be interpreted in light of the common law. So you speak of history in the common law. Isn't it true that a person had birthright based on where they were born?
Yes, Your Honor, but we also acknowledge and have seen throughout history that the British government never actually upheld to that decision made in the Calvin case. Interestingly enough, the British Empire only acknowledged that their colonial expansion, those residents, the only similarity they had to people who lived in the UK were that they were under the monarch's rule. It wasn't citizenship in the way we say it today, and it wasn't explicit citizenship as were residents of England, Scotland, and so on. And additionally, you mentioned the concern over the insular cases, and I respectfully point the court's attention to the transformation that the insular cases have had over the past 100 years. It is not lost upon the government that its rationale is rooted in racism. But what we've seen time and time again with Balzac v. Puerto Rico, Reed v. Covert, and Boumediene v. Bush is that this rationale has been whittled down again and again and again to hold only the holding that limits the court and allows Congress to handle policy issues such as declaring the citizenship of those in unincorporated territories. So while its roots are found in racism, this court has made the effort to remove itself from that and focus solely on the judiciary limitations. Additionally, there is one component of Downs v. Bidwell that plays significance today. As mentioned before, Article 4 discusses the Congress's role in handling territories. Sims v. Sims discusses that they have entire dominion and sovereignty. And Downs v. Bidwell is interesting because it discusses treaties. In terms of histories, treaties again and again play a significant role because they establish the consent between the U.S. government and the territory and their process to becoming citizens. In Downs v. Bidwell, this was reaffirmed. Treaty, as Justice White said, treaty implies that the persons of a territory will be taken in a particular way as per the U.S. government. So it's different than a state. It's not automatic. And there is reason for us to believe, going back to the 14th Amendment, that when they were deciding this, being in a state mattered a lot. That is because of the Dred Scott decision. It is not lost upon the government that the 14th Amendment was created out of a necessity to overturn Dred Scott. And the reason for this was to allow freed slaves to become citizens of the states they resided in and of the nation. So even if we take Senator Turnbull's quote, and albeit it is one quote, even if we take that quote, there is enough historical reason for us to believe that by removing Congress, Senator Turnbull was referencing the need to not have an issue such as the Civil War arise again, and allow that these freed slaves automatically obtain the citizenship they deserve. Moving forward,
I had a question
yes.
I want to ask you about. Samoans, as you know, have a high enlistment rate in the U.S. military, and so they serve our country in numerous ways that most of our citizens don't. And they're also already afforded many rights that go with citizenship when they're here in the country. So it strikes me, aren't we really already treating them as citizens and using an artificial framework to deny it to them?
No, Your Honor, I do believe that while they're treated close to citizenship, they're treated as nationals. And not making them citizens explicitly matters because it does protect their culture. And it is the terms of which the United States and the government of the American Samoa agreed upon over 100 years ago.
Whether or not they agreed to that 100 years ago, I'll ask you the same question I've asked others. Why should the people in a subjective interpretation make the decision on a constitutional right, which we normally look at on an objective basis? Why is this cultural determination by some able to overrule an objective constitutional interpretation?
Your Honor, I do not declare that the cultural sensitivities are what is entirely taking out the question of citizenship. Instead, that comes from a culmination of Article 4, explicitly mentioning territories, the insular cases making the distinction between unincorporated and incorporated, Congress's 6 times in which they declared the citizenship of Guam, Puerto Rico, the Virgin Islands, and the Mariana Islands. All of this brought together creates a solid foundation for us to say unincorporated territories are not included in the 14th Amendment. Now, the cultural sensitivity component more so plays into the consent of the people. So when
why do we care about the consent of the people if we're trying to decide what the language of a constitution means?
Because it helps us make a decision on whether or not their sovereignty should be respected, how to respect it, and how to incorporate them into the United States if they agree to it. Your Honor, they are only in the United States as of now because of our treaties and delegations with them. So their consent mattered, especially at that time, because otherwise they would not be owned as a territory in the United States. Additionally, I would like to speak upon the consequences of applying citizenship through this court. As per Article 4 of the Constitution, Article 3, excuse me, as per Article 3 of the Constitution, we understand that Congress has a significant role in handling treaties. The executive makes the treaty. I see my time has run out. May I conclude?
Finish your thought, please, and then wrap up.
Thank you, Your Honor. As per the article of the Constitution, treaties are given by the executive and approved of by the Senate. So for this court to overturn that and to declare citizenship of the American Samoan people, it would undermine the authority of the Senate and the authority of the executive, and that is something to take into strong consideration as we decide whether or not and how to approach this issue. Your Honors, in preservation of their culture, their history, and their way of life, we respectfully request that this court uphold the decision of the court below us. Thank you.
Okay, thank you. Okay, thank you, counsel. We're going to, what? Oh, I'm sorry. You're right.
Hold on.
May it please the court. Respondents contend that the Constitution doesn't apply unless Congress says so. The nature of the Constitution is that there are some rights where Congress doesn't get a say. Congressional wrongs do not supersede constitutional rights. Our argument is much simpler. In the United States means in the United States. And the authors were clear on that point. The respondents contend that they didn't mean for the 14th Amendment to apply to unincorporated territories, a distinction that had not even been created yet. The authors of the 14th Amendment agreed with Loughborough v. Blake, in which Chief Justice Marshall said, "The United States is the name given to our great republic, which is composed of states and territories." Respondents believe that a history lesson on England and Scottish common law is well and good, but what matters is the text of the Constitution and what the judiciary is empowered to do about it. Justice Robb, you mentioned the importance of the Constitution towards protecting minority interests, and that should be central in the mind of this court as they decide here. The fact is that the American Samoans do not have adequate representation, and they need the judicial branch to use their powers to protect them. Mr. Chief Justice, you talked about the stability of the precedent in Wong Kim-ark. And we would refer also to the precedent of Reed v. Covert, in which they said that we should not extend the insular cases. That is the most recent precedent. The insular cases, especially Downs, dealt with tax uniformity. This is something far more fundamental in citizenship. And lastly, Justice Thomas, you mentioned the fact that Samoans don't have a remedy through the democratic process. That centers the point that the judiciary is the proper channel for which to achieve this right for the American Samoan people. Lastly, I would just say that Dred Scott was wrong because it denied a right that was naturally conferred. May I briefly conclude? Because it denied a right that was presupposed to be possessed by the framers. And this court and the authors of the 14th Amendment intended to pass the Citizenship Clause in order to remedy that action. And for that reason, we humbly ask that you reverse the Court of Appeals decision. Thank you.
Thank you. Okay. Thank you, counsel. We're going to adjourn for a brief recess and deliberate the case.
I don't know.
Did you see the box sets too for the judges?
Oh, no, I did not see those.
Okay, please be seated, everyone. So I would begin by saying that on behalf of the entire court, that we were incredibly impressed with the four of you. That I think that when we reflected on some of the questions we asked, that we realized afterwards, oh, you know, that was kind of getting out of the problem into more like law school stuff. But you had us that convinced that you all were lawyers because you did such a thorough job. You answered our questions so well. One of our dilemmas was that different styles of advocacy. And again, I think that each of the four of you was incredibly persuasive. You knew the materials inside and out and did a fantastic job. As we agonized back there and fought and went back and forth, we ultimately reached a consensus that we could not select only one finalist winner this year, and so we had to go with co-winners, and in doing that we have selected Mr. Buckley and Mr. Kirkpatrick. And so now I want to invite any colleagues on the bench to make any comments.
As an appellate judge, it was very hard for me to remember that you're not actually lawyers arguing in my court. I thought you handled the questions amazingly well, knew the material, knew the background, knew things that we were throwing you curveballs on, and you did just a terrific job. You're going to have success in whatever endeavors, whether it's law or some other career. Public speaking is always an advantage no matter what you do, and you're just terrific.
Yes, I echo that. I was sitting here thinking, boy, I don't want to go against any of those people in a few years. It is amazing to me that you fellows can take what I thought was a complicated problem with not a lot of good precedent going either way, which is what I struggled with. But synthesize that into persuasive arguments and presented them well in a short period of time. And it's not exactly as if you're not doing anything else during this 3 or 4 week period. So I think what you fellows accomplish is really remarkable, and I hope you do all become lawyers and appellate lawyers, because I think you'll do a great job. I think it's just amazing that college guys can do that kind of work.
So I'm going to give you all a little bit of feedback individually. I know nothing about law. I know something about presentation. Mr. Goodwin, I would encourage you to be a little bit louder and enunciate a little bit better. I had a hard time hearing you sometimes, so I think for me that was tough. I had to keep kind of leaning in, and I had a hard time following some of your argument because I couldn't hear you all the way, right? Mr. Buckley, I know how thoughtful you are because I've had the pleasure of having you in class, and I'd like to see that thoughtfulness come out in a little bit more confidence when you're talking. Mr. Grabill, same thing with the volume. I had a hard time hearing you sometimes, but also I felt like you were not as assertive as I wanted you to be with your, I felt some lack of confidence at moments in some of the things you were saying. I felt like you would sometimes get thrown off a bit, and I could see it, and I don't want to see it, right? You've got to do a little bit better job of covering that. And then Mr. Kirkpatrick, I'm familiar with your style, and I would, I think my suggestion would be to read your room a little bit more in terms of when you can be assertive and when you have to be a little bit more reserved in the way that you present your information. You clearly know the information, but the way that you present the information. So you're a bulldog, right? You don't always have to be a bulldog, right? Those would be my thoughts. But good job, all of you. This was awesome.
As a final comment, I think that one other thing that we talked about that you guys did an amazing job with is returning to the points that you have to make, even though you've got 4 people doing their best to draw you off of your script, because you go into it saying, I want to get through all this stuff, and we're firing all these questions. And I think that as a group, you did an amazing job of being very poised, not being at all thrown off by the questioning, answering it in a responsive way, and then returning it right back to where you wanted to go. So again, I just think that all of you guys did a fantastic job, and congratulations to all of you.
Would you join me in thanking our panel of judges? We have another prize that we give at the Moot Court competition. It is the Floyd Artful Advocacy Prize. It honors the memory of Douglas Floyd, a Hamilton County lawyer, remembered by his colleagues as an artful advocate of causes he believed in. The winner is to be not only a successful advocate, but also kind, tactful, and principled. As lawyers might say, he succeeds without scorching the earth. What we seek with this award is not only winning qualities as an advocate, but also a winning disposition, someone who can take the heat with a smile. Funded by gifts from Doug's colleagues, friends, and family, given at the time of his death in 2001, Doug's wife, Lisa, and his son, Riley, Wabash class of 2013, established the prize in 2019. Selection is made by the faculty members who organize Moot Court, and the award may go to any of the 4 Moot Court finalists. We are happy to award the Floyd Artful Advocacy Prize for this school year to Jackson Grabill.
Excuse me. Oh, my goodness. My eyes just...
Yeah, this is everybody.
Oh, with the judges, sorry guys, with the judges.
He meant take your robo. Shoot some leaves, please.
Oh, wow.
I know they get fun.
Oh, wow.
It gets
Thank you very much for the beautiful gavel. That is. That is great. I will probably have this in my bench.